Welcome back, everybody, to our studies in the history of English law. This lesson is going to be moving on to looking at the next major theme that emerges out of the English legal system prior to the Norman conquest. And this is prior to anything that we could generally consider to be England. In fact, it is under the Anglo-Saxons that we see the establishment of what becomes known as England, which we'll get to in future lessons' time. But fundamentally, this is the second sort of period of history that is prior to the Norman conquest, but is still nevertheless important for the development of the English legal system. And this is the legal system of the Anglo-Saxons. Now, generally speaking, the Anglo-Saxon period and the legal system of the Anglo-Saxon period is the sort of legal system that emerges in the early 5th century AD after the collapse of the Roman rule in Britain. So the Romans essentially leave, and we see this sort of period from the 5th century AD all the way up to 1066, when we see the Norman conquest and the collapse of the Anglo-Saxon period. It would evolve as a legal system over a number of centuries, and it was based on a number of local customs, traditions, and the combination of a kind of Germanic tribal law with, as we will later see in the sort of 6th century, the establishment and the incorporation of Christian principles as well. And there are obviously different periods from the 5th century all the way up to 1066. It's a period of around 500 or so years, and there are very key figures within each of these different centuries in this different period. So, for example, we will talk in a future lesson about Alfred the Great. We'll talk about Edward the Elder, Alfred the Great's son, and then Athelstan, who obviously becomes the person who is responsible fundamentally for the establishment of what we become known as the United England that we see today. Prior to Athelstan and under Alfred the Great, you see the existence of what is known as the Heptarchy. This is a period of time in which you have a number of kingdoms within England that are all sort of divided, and then you have the influence, of course, of the Vikings, who that land in Lindisfarne in around the 700 AD, shall I say, the 7th century AD, and we'll see all of this take place, and we'll see how all of this sort of incorporates into each other, and we sort of see how this develops into a legal system that we know of today. The Anglo-Saxon legal system, in terms of sort of broad characteristics that we can think about it, was unique for its reliance on customary law. It was unique for its reliance on unwritten laws that were based on tradition and sort of passed down through word of mouth. This was an emphasis on compensation as well, rather than, for example, punishment for crimes, something that, again, we will look at in future lessons. I just want to finish this video then by thinking about a variety of different sources of Anglo-Saxon law, where Anglo-Saxon legal systems and legal traditions come from. And one such example is something that we've already just touched on, the idea of customs and local practices. And it is definitely true that the idea of customs and local practices formed the bedrock of the Anglo-Saxon legal system. They were not written down initially, but were passed on orally within communities. So the early Anglo-Saxon period, so the 5th century going all the way to maybe around the 7th or 8th century, we see a consistent practice of passing orally through communities these different local customs and local practices of Anglo-Saxon law. It is only with the writing of substantial law codes and the writing down of a variety of different things that we start to see the establishment of more written sources for the Anglo-Saxon legal system. These customs would also vary from region to region among the Heptarchy, so they would reflect the variety of different tribunal origins of the Anglo-Saxon kingdoms. So the sort of three major kingdoms within the Heptarchy were Mercia, Wessex, and Northumbria, and generally speaking, these would have become united eventually into an England that we know of, and this would take place sort of foundationally beginning under people like Alfred the Great, who sort of saw a sort of vision of a united England, and then we see more substantially under his grandson, King Ethelstan, the establishment of a more united England as well. And so you can't really think about the Anglo-Saxon period and the Anglo-Saxon legal system specifically without reference to the monarchies that existed and the nature of kingship, the nature of monarchy during this period of time. As these Anglo-Saxons as these kingdoms became more and more centralized and they began to become more and more institutionalized and more sophisticated in the establishment of law and order, the kings would start to issue what were known as law codes. These law codes did not necessarily seek to replace any of the principles of customary law, but rather to try and supplement it instead, especially when we think about areas related to things like public order and criminal justice and the protection of royal interests. Now, public order, I'm using a sort of modern conception of the term public order, but things that you would generally consider to be public order based legal systems is what I'm talking about in relation to this. Of course, public order as a phrase is something that's a lot more modern and refers more to the sort of the police codes of practice that exist in the modern period of the United Kingdom. Now, as I noted, it was the sort of 2nd century of the Anglo-Saxon period that we see the establishment of Anglo-Saxon law codes. At least the earliest surviving Anglo-Saxon law code is that of King Ethelbert of Kent, which was around circa 602 AD. Now, this was a law code that also was influenced by the introduction of Christianity into the region as well, and we'll get into, on the next slide, looking at the influence of the church and Christianity. But it is considered itself, the law code of King Ethelbert of Kent, is considered to be one of the oldest written laws in English history. And more law codes will be established, some of which will become more influential and more impactful than others, but at least the very earliest surviving law code is that of King Ethelbert of Kent. We may have evidence to suggest that there are law codes that may have existed prior to this particular one, but at least in terms of the ones that we have and that we can actually look at and that we can see, this is the earliest one that we have. And so finally then, thinking about the variety of different sources of the Anglo-Saxon legal system, we can think about the influence of the church. The Christianization of England begins in around the 6th century and into the 7th century, and the church, as a result of this Christianization of England, becomes a very influential institution within the English legal system. And so church law, sometimes described as canon law, addressed a number of very important moral and spiritual matters. So things relating to and influencing inheritance, morality issues, and marriage all were sort of wrapped into the sort of body of canon law that existed. In addition to this, laws that had any kind of moral dimension, and in some cases a lot of laws had quite a significant amount of moral dimension. You would see that there was either the direct addressal by the church, by church law, or at least the influence of church law. The church would play an important role, therefore, in things like the administration of justice, especially when you think about the establishment of what become known as ecclesiastical courts. In addition to this, at the local level, law was often administered by assemblies known as moots or folk courts. And so these were considered to be gatherings of freemen who would come together and adjudicate disputes in the enforcement of the customary law, usually local landholders. And so thinking early about this period of the Anglo-Saxons, it's not correct necessarily to sort of tarnish or at least to sort of paint a broad brush about Anglo-Saxon legal traditions, because the Anglo-Saxons definitely developed and become more sophisticated and more institutionalized as time goes on. But at least in this early period, the sort of 5th, 6th, and 7th centuries, you see at least the very clear amount of common customary laws that are established, and the way in which these customary laws were passed from person to person were very much through word of mouth, rather than necessarily being written down and established in a more institutional format. You also have to think about the fact that there was a certain degree of fragmentation, given that we're not actually talking at this period of time about England as it exists today, or England as it exists after the Norman conquest, for example. We're talking about a variety of England that is divided among a system of different a system of different kingdoms. You've got Wessex, Northumbria, and all these different kinds of systems. And so you have to think about it not necessarily as a united England, even though we sort of generalize the Anglo-Saxon period as being described as Anglo-Saxon England. That's not exactly how the Anglo-Saxons at the time saw their allegiance to a particular kingdom. They would see themselves as being allegiant to Wessex or to Northumbria, for example, or any other kingdom within the heptarchy. We do get a more united England as time goes on, especially when we see the influence of the Vikings and the establishment of Daneland and the Danelaw as well. But at least at this early period, we don't have this clearly united system of England in the same kind of way, despite the fact that, of course, historians and people who write books on the history of England sort of just describe this colloquially as Anglo-Saxon England.